Can USCIS take away your green card if you had it for more than 5 years, but you obtained it incorrectly? I'm going to discuss that and more. Hi, I'm immigration attorney John Khosravi. And since I've been practicing, a lot of people have said, and I've heard here and there, that if you've had your green card for 5 years, regardless of if you obtained that green card incorrectly or if there was misrepresentation to obtain it, they won't take it away and can't take it away anymore. Well, there was a case that came out last week in the Ninth Circuit, and the name of the case is USA v. Phatty. And this led me down a rabbit's hole to really dissect the statutes that are involved and find out what really the situation is. And I wanted to help you better understand it as well and to learn about it. Just keep in mind, these things change constantly and up to interpretation as always since it's law, so do your own research. But to start, in USA v. Phatty, there was a gentleman who had applied for asylum, and he had some history of asylum fraud related to that. But he was able to get the asylum claim, get a green card, get citizenship, and then 7 years later, they realized that he had done this asylum fraud because his fingerprints came back and they matched a previous false claim of asylum, and so he got in for denaturalization. And he tried to keep his green card by saying that I've had my citizenship for more than 5 years and had the green card for 5 years as well. You can't take this away from me. Now, there is a statute, 8 U.S.C. 1451A. And this statute says if you did misrepresentation in the past, they can't denaturalize you or revoke or rescind your citizenship and take it away. However, the person here, the applicant here, was arguing that under 28 U.S.C. 2462, there is a limitation of how long they can go back after a certain time to take away something like that, and that it's a penalty to do something like that. And the court analyzes it and it comes up with the idea that under that second statute I mentioned, it's not a penalty to take away naturalization, so that 5-year statute of limitations doesn't apply, and they can denaturalize this person. So that was the story of that case, but once I started reading the statute, I started digging in a little deeper. 8 U.S.C. 1451A, the denats action and breakdown, it finds itself actually gets the original power from I&N 246, Immigration Nationality Act 246B, also known as 8 U.S.C. 1256. Now this statute 246, and I like to use the I&N when I'm talking about this stuff. So in I&N 246, I&N 245 is adjustment of status statute. I&N 246 talks about rescission. And I&N 246A, the first portion, says that if you had your green card for 5 years, that it can't be rescinded afterwards. And then 245B says if you have citizenship and you obtain citizenship based on fraud, they can denaturalize you and take that away, open it up and take away the green card. So one thing that pops up in people's mind is, well, maybe you keep the green card but never file for naturalization, because that's usually when people get caught, which is one of the ways people get caught when they have had misrep or mistakes in their adjustment of status in the past. But when you look at 246A, the question does come. So if they had that misrep to get that green card, could they keep their green card 5 years to pass? Well, there's an interesting story that goes along with this, but to start, I went to Adjudicator's Field Manual, AFM, and looked into how they look at this rescission statute. And they said something we rarely do, and you should really look into it really hard before doing it. And there are some, case law, BIA's kind of stuff that said if they are going to do a rescission, the date that you receive notice of rescission is the date that it gets locked in. So the idea that you get notice that they're going to rescind, and then a judge makes a final determination. The final determination of the judge doesn't have to happen in the 5 years. It's just that initial notice to action, notice to appear that comes in, that their idea that they're going to rescind is when the timeline stops within that 5 years and they can't do it afterwards. Okay, that's easy enough. And there was another case. That case was called, the first case I mentioned was matter of Pereira. The second one I'm going to talk about is matter of Carrillo. This was a Cuban adjustment, and kind of like asylum, where once you adjust, they backdate the adjustment date. And this person said once they backdated it, it didn't fall within 5 years when they want to rescind, but the court said, and the BIA said that no, the rescission time starts from when the adjustment is actually approved. So that's good enough. I was excited reading that there's such a thing of blocking rescission after 5 years, because mistakes happen every once in a while. But once I dug in deeper, I realized that's not really the case, unfortunately. Now, the statute, I&N 246A, has changed over the years. So previous to, in the early 90s, I think IRIRA time before that, it was written a certain way, but nowadays it's written differently. And most of the circuit courts, almost everyone that has dealt with this issue, which is almost majority, have said that essentially 246A doesn't even exist. So let me get into that. I'm going to analyze one case, Adams v. Holder in the Second Circuit, that really breaks this down. And many of those circuits in the Fourth and so on have agreed with this line of thinking, which is this. I&N 246A says that the Attorney General should rescind if they find out that there's been some sort of misrepresentation that happened in the last 5 years. So, okay, good for the applicant if it goes past that. However, they say specifically with regards to rescission, there's a 5-year timeline. It doesn't say removal. And to them, removal and rescission are different procedures and different issues. So they can still initiate removal. And there's nothing in the removal statutes that sets a timeline. Let me say that again. There's nothing in the removal statutes that sets a timeline of when they can reopen and resend an adjustment of status green card case. So that's very important to note. Another interesting thing they talk about in this is that this 246A rescission statute only applies to adjustment of status and not to consular processing, because the statute specifically talks about adjustment of status. But it doesn't really matter, because what the DHS will do is, instead of rescinding, they'll just go to court and NTA you for removal proceedings, and the timeline doesn't really matter at all. However, in the Third Circuit, and this really came up in the case of Bamidele v. INS, they had a different interpretation, and they stuck with it in a subsequent case, and they said that no, we interpreted that the 5-year limitation for rescission also applies to removal. So if you're in a Third Circuit, you have some protections there, but you can bet if this issue comes up, the DHS is going to fight it, maybe take it all the way up, because the rest of the circuit courts that dealt with it have been on their side. So unless you're in a Third Circuit, if an issue pops up where there was misrepresentation or any other issue in the attainment of the adjustment of status green card, the DHS will issue removal proceedings based on the removal statute and avoid the rescission statute altogether. So this 5-year timeline of protection doesn't really exist, and I would not rely on it or tell clients to use that or have some sort of relief from it, because as we've seen this most recent case that I started with, the Ninth Circuit case, the USA v. Phatty with a PH. In that case, the guy had naturalization, and 7 years had gone by since Nats, and it didn't matter. They still rescinded it. The guy's in removal. He's going to be kicked out unless some other protections come. So I thought it was a really important thing to talk about and bring up, and to go into this case law and the statute. It's very interesting stuff, how nuanced immigration law is. I hope this information helped. You can always go to the immigrationlawyerstoolbox.com for more information. The YouTube page for immigrationlawyers.com is available with a lot of videos and updates as well. And as always, the Immigration Lawyers podcast is there. You can find it wherever you find podcasts, where I regularly talk about immigration news and events for practitioners of immigration law, so you can be updated on what's going on. Because as you know, it seems, I used to say every couple of years things have changed, then every year, 6 months, every day. Now it seems like every 4 or 5 hours something's changing. So I'm doing my best to be on top of it, to get this information and get out to you. I hope this information helped. Until next one, have a good one.